Lauren, you have the floor.
Thank you, Chairman Spiros, Vice Chairman Piwa-Warchek, and members of the Committee on Criminal Justice. I did my best, I'm so sorry. And Public Safety. Thank you for the opportunity, providing me with the opportunity to testify in favor of AB Bill 91. My name is Lauren Greuel. I am Associate Counsel at the Wisconsin Institute for Law and Liberty, and I've been serving as counsel of record for plaintiff in Aubegrin versus Milwaukee Board of School Directors et al. In Milwaukee County Circuit Court. Today I'm here to explain why AB 91 is necessary to ensure compliance with Wisconsin Statute Section 62.90 subsection 8 and to prevent the ongoing disregard for legally mandated school resource officers, or as we've been calling them, SROs. Charlene Aubegrin, Will's client, and the plaintiff in this case, is the parent of 6 students who've attended Milwaukee Public Schools, or MPS. She and her children have witnessed and experienced violence in MPS, incidents that could have been deterred or better managed had the school resource officers been present. Current law requires MPS to have no fewer than 25 school resource officers in place by January 1st, 2024. It's March 5th, 2025. Not only did MPS fail to meet this requirement, but its board members openly criticized and laughed at the obligation. With safety at risk and no enforcement mechanism in the statute as it is currently written, Ms. Aubegrin was left with no choice but to pursue legal action. Will had to seek a writ of mandamus because Wisconsin Statute Section 62.90 subsection 8 does not specify what should happen if MPS or the city fails to comply with the statutory requirement. AB 91 addresses this deficiency by introducing an enforcement mechanism, withholding per pupil aid from MPS and supplemental county and municipal aid to the city if they fail to comply. This provision ensures that compliance is not merely suggested, but required. Judge Borowski's rulings further underscore the necessity of AB 91. In January 23rd, 2025, in that hearing, Judge Borowski agreed with Will that MPS was out of compliance and ordered the district to have 25 officers in schools by February 17th, or explain why it could not. MPS failed to comply, arguing that cost-sharing negotiations with the city were unsolved. Given the lack of statutory guidance, the court then had to step in and impose a 50-50 cost split between MPS and the city. Even then, neither party met the next court-imposed deadline, leading to the court to again agree with Will and find that the city of Milwaukee was in contempt of court. AB 91 eliminates the ambiguity that led to this impasse by establishing a clear 75-25 cost apportionment between MPS and the city respectively. Unlike other districts across the state that voluntarily agree on SRO funding between the district and local law enforcement, MPS and the city have demonstrated an unwillingness to comply without legal intervention. AB 91 ensures that Wisconsin courts do not need to repeatedly enforce that law that should have already been followed by requiring the Department of Public Instruction to withhold 20% of the per pupil categorical aid payment owed to MPS and the Department of Administration to withhold 10% of the municipality's total payments under Wisconsin Statute Section 79.037. Beyond enforcement, AB 91 is a matter of student safety. Violence in MPS is an ongoing crisis. The absence of SROs has left students, teachers, administration, staff, and as we've been discussing, the Milwaukee community at large, vulnerable to preventable harm. A clear, enforceable statute is necessary to uphold the safety of students and to restore order in Milwaukee schools. If not for a courageous mother stepping forward and bringing this lawsuit with Will, MPS and the city may have continued violating Wisconsin law indefinitely. The updates AB 91 provides to Wisconsin Statute Section 62.90 sub 8 are essential to ensuring compliance without further court intervention. Lawmakers have a responsibility to advocate for school safety laws, and AB 91 provides the tools to do just that. Thank you for your time, and I'm happy to answer any questions that you may have.
Thank you. Representative Jacobson.
Thank you. I just had a couple questions. Believe I know the answer, but just to emphasize, and you hit on it towards the end of your testimony, the $1,000 a day penalty that's presently in place, there's no guarantee that, so for instance, in the future, should MPS or the city choose not to comply with the law that they have 25 in MPS schools, your $1,000 a day penalty that's being levied is gone. I mean, the court's jurisdiction is over when the case is over. Is that not correct?
Correct. So
You would need, in other words, a whole new set of facts, a whole new case, a whole new plaintiff, and get back into the slow, arduous process of the court system to get compliance again. Is that correct?
Correct. The way that the sanctions, the remedial sanctions, are currently being imposed, the $1,000 a day fine is going on as we speak, but the city has the opportunity to purge that fine if they comply with certain aspects by March 15th. And then on March 17th, we have a hearing to evaluate whether or not those components were met. If at that time the city has met all of those components, the $1,000 fine will be purged, and it will no longer be the motivating factor that it is right now for the city.
And then just one other question for you. Do you have, or can you comment on where the 50-50 split came from the court's order? Did the court just think that was fair, or was it a suggestion of the parties by stipulation?
Right. So in part, just based on when Judge Borowski was making his rulings in the hearings, he mentioned that the previous agreement between MPS and the city for SROs was 50-50, and I believe that was the basis for his rationale.
Okay, thank you.
Representative Spotty.
Thank you, Chair. Thank you, Counselor. I'm trying to figure something out here, and I'm genuinely curious. The statutory requirement the statutory requirement took effect January 1st of last year, 2024. Your client, you didn't file a complaint until October 8th, 2024. If this was such a grave concern of public safety, I'm curious why the delay? Why a 9-month delay? Why did your client sit on her rights for 9 months?
Yeah, absolutely. That's a great question. And the answer to that question is a hope of compliance. We were monitoring since January 1st, 2024, whether or not compliance in the law would be followed. There were several meetings at MPS where they talked about the fact that they were sending school board members to other states to see what they were doing. They were holding listening groups, that kind of a thing. When it became clear that MPS had no intention of actually following the law, that they weren't just delayed in getting the SROs in schools. This was in July of 2024 when Vice President of the School Board of Directors at MPS laughed at the requirement, that we became in contact with our client and we started drafting the things that we needed to draft to file in court. We filed in September a letter with the Milwaukee Public School Board of Directors, a letter requesting that they comply with the law. We gave them additional time to do so. We said, we'll have to file a lawsuit if you don't. Again, something we shouldn't have had to do at all in the first place. It should have just been something that they were working on, but they weren't. So after that time limit had passed is when we filed 2 days later our lawsuit on October 8th. So we were monitoring to just see if it was a delay. A lot of things at MPS right now are in delay. They're out of compliance with a lot of different aspects of the law. We were hoping it was just an oversight or something that they were working on. When it became clear in July that that was not the case is when we began filing what we needed to have ready for the lawsuit and got in contact with MPS asking them to comply with the law, and then we filed the lawsuit. So we were working on it since January 1st of 2024 is the short answer to that question.
Short answer, but 9 months is a long time. I guess I'm not satisfied, but I appreciate the answer. You filed a petition seeking a writ of mandamus.
Yes.
Is that available? from day one on January 1st? Was that relief available to your client on day one?
So for a writ of mandamus, there are 4 different requirements that need to be met in order for a writ of mandamus to be given, and there's a couple different aspects to it. I'm off the top of my head trying to remember them all. One of them is there's a plain and positive duty under the law to have officers in schools. That was one of the things that potentially could have been met. Another thing was substantial harm to the client, which is something that we continued to see after MPS decided to be out of compliance with the law. And then no other adequate remedy at law, which is really what we're here to talk about today, right, is creating an adequate remedy at law to ensure that MPS and the city do follow the law so that lawsuits are not necessary. I will also say that it would have been premature on January 2nd of 2024 to bring a lawsuit. We probably would have been given the direction by the court to allow them additional time. We've seen that since we had our hearing on January 23rd, 2025, that MPS and the city have now been given an additional 6 weeks to comply with the law since an order from a judge was given. These kinds of things, unfortunately, are delayed, but that's another reason why it took 9 months to bring a writ of mandamus.
Back to my original question, was that relief available to you on day one, Counselor?
Theoretically, I suppose I could have brought a lawsuit on January 2nd, 2024. I doubt that the judge would have agreed that that would have been appropriate.
And was it useful when you were able to obtain that writ? Was that useful for you?
Was it useful for the judge to order MPS to comply? I guess I don't understand the question. I'm sorry.
Are you happy with the outcome of the judge's decision? You were given the relief.
Guys, we need to really stick to the bill rather than the lawsuit. So, I mean,
Get a better sense.
I understand that, but that's not what we're here for. We're here for testimony on the bill. And, I mean, I've allowed a lot of questions to go on that, I mean, it just, if you want to answer, go ahead. But, you know, from my standpoint, I understand what you're trying to get to. But the bottom line is there's a bill that's brought by the legislature, and Will's testifying in favor of it, but it's not their bill. You had a chance with the authors if you needed to ask other questions on that, but quite honestly, what happens in court really doesn't pertain to anything that we do here. So that's all I'm saying. Go ahead and...
Well, I'm learning the parameters. I will withdraw that question. All right, thank you.
We have too many attorneys on this. That's what I got to say. My God. Well, yeah. Oh, my God. That's okay. No, well, I do. It's not that I don't appreciate attorneys. I appreciate the questions. It's just we're really not in a court of law, and we got to watch as we're going down. We've got to really stick to the bill, okay?
Wait until he uses the gun.
It's on the right side. I'm left-handed, so I've tried to.
And he's good at it.
All right. Thank you very much.
Thank you.
Registering in favor, or registering against.